of a flying visit through some of the contract issues. What I want to cover off on or talk a little bit more about is the electronic signature rules, the way that that framework fits into an international context, and have the potential, if we want to do it, to talk in a bit more detail about the consumer law provisions and have a chat about how they continue on. Then after lunch, so I want to finish at 1 so that we can be back at 2 on the dot, and Julian Ubergang from Neotologic is going to come and talk to us about what he's seeing happening in the world of artificial intelligence, particularly in connection with the practice of law, but also the kinds of issues that he's seeing coming up. He's not a lawyer, again, so he is General Manager for Australia, I think, of a company called Neotologic, which has been providing software tools to law firms who are developing AI apps. So that's the context that he's coming in from. And then, thanks to the lovely Coco here, tomorrow it turns out that we have a guest from AUDA, AUDA, coming to visit us, in the CEO no less. So he will be able to talk much more broadly about some of the disputes work that we touched on last time, but also has agreed to talk about the role of internet infrastructure, physical infrastructure and things like the domain name system in as a broader utility factor in Australia's infrastructure. So how he sees, for example, the role of the internet or availability of domain names in Australia's infrastructure environment. So, sorry, I'm not explaining myself particularly well. So when we were talking about what he would talk about, he's really interested in what the risks are if the domain name registers were to go down, how that would affect Australia's security, how it would affect commerce in this country, what the role of AUDA is and what it should be. He's relatively new in the job, and so how it fits into the whole regulation and role of the internet generally. So I think that could be a really interesting, possibly quite controversial discussion that I know I'm going to enjoy. Hope you do too. So in between that, I want to finish off a little bit about contracts. We didn't talk about jurisdiction last week, and I think given the nature of the projects that you're all working on, we do need to have a visit to the issues of jurisdiction and how jurisdiction fits. I also want to have a conversation with you today about the assignments that I've marked so far and where they're at. Everybody's got their feedback? Yeah? Nobody's thinking, no, I don't have any feedback?
We were a late submission, so...
No, you got them all done. So they should be in your, you didn't get them? It's in the group area. If you, so the person who submitted would have got them, and in your Blackboard group I put them up, and there was an announcement that said that's where you would find them. So if it's not there and I haven't put it up, I absolutely apologise. But if it's not there because you haven't looked for it, so because I waited till I had them all. So I would like to just have sort of probably after we finish with Julian today, just have a little discussion about that, just to make sure everybody's comfortable going on the right track, and do a bit of feed forward on what I'm expecting for the presentations in a couple of weeks. Happy? On that note, I will make a noise so I can work out where to sync my recording. So, contracting in an online world. I really enjoyed Gordon's presentation, and I really liked the way that he pulled together the concepts that we've spoken about in contract law, those of you who did it with me, and those of you who did it with somebody else, I'm sure, in pulling together what those concepts were and how they fit into electronic contracting. And we really, in Australia, there is no real controversy. As you can see, the key case, the eBay case, and it's often referred to as the key case, as Gordon said, really doesn't question whether or not a contract could be made online or not. And that's entirely consistent with the principles as we understand them. So, what do we want to talk about here? So, where I want to really phrase this is in the context of Australia's international obligations. So there are a number of international treaties and international frameworks under which online contracting has been discussed. So the most important of these is usually referred to as the UNCITRAL, or the United Nations Convention on the Use of Electronic Communications in International Contracts model. So lots of words, but essentially nothing very special or exciting. So Australia's ratified the UNCITRAL model law, and in theory at least is about to ratify the 2005 Convention on Electronic Communications in International Contracts. I say in theory because I think the bill's been put up a couple of times, and in the last couple of years we have had parliaments that have chosen not to make it easy to pass pieces of legislation. Unless you got an extra $100 million for land care, can't get anything through, it seems. Anyway, that's for a different day. So, as at November last year, and I have checked since, and I haven't seen anything that's happened since. The states that have ratified UNCITRAL are the Congo, the Dominican Republic, Honduras, Montenegro, the Russian Federation, Singapore, and Sri Lanka. Not exactly a group of countries, Russian Federation potentially accepted, but for different reasons, that we think of as massively international trading online contracts. So, is there anybody in the room, I'll go by exception, who hasn't purchased anything online? Is there anybody in the room, for those listening at home, there was nobody who gave that indication. Is there anybody in the room who has only ever bought things online that they know came from somewhere in Australia? Yeah? So most people involved in international trade and commerce or have been on at least one occasion. Are there any of you who would purchase something in the order, just looking back at the last year, in the order of once a month or so from overseas? I'll put my hand up there. Maybe, on average, across. So, what places are you contracting with? Sorry?
USA.
USA?
China.
China? Big AliExpress fan here. UK. So, Germany. All over the world.
Irish, Dutch, Irish of Apple. Or
Amazon, yeah.
Whatever those jurisdictional issues
So, so Ireland, yeah, basically, or maybe somewhere in Holland or Brussels. Yeah. None of those places that we've just mentioned are signatories to these or have ratified these conventions at this stage. So we do have this international framework. So I just want to pose the question to you as an issue. Have you ever turned your mind to what an international framework might be when you've been deciding whether to buy something online? Have you been, I know I was quicker to purchase from the States. It took me a little longer to get comfortable with the idea of leaving my credit card details with AliExpress. Now I'm on the app. I do have a separate credit card with a very low limit that I use pretty much for online shopping, but that's just because I worked in financial services and yeah, I get the heebie-jeebies every now and then. But do you think about the source? Would there be other reasons other than your own consumer protection that you might think are the source of those goods?
I wonder if people are making decisions somewhat based on the value of the item and knowing at the back of our head, if this falls over, I've lost $100, but I haven't lost $1,000. So we're weighing up the risk. What do people think?
What do you think? I know I think about that when I'm buying small electronic goods, I don't know if you've noticed, but I'm a bit of a fan of gadgets. And I'll see something advertised. One little thing I'm waiting for at the moment is a USB charger for my phone that is, it's made of metal, so I can put it in the car, it'll stand up and my phone will sit there and I can charge and I don't have to have a cradle for it. I'm very excited about that. I saw it advertised on Facebook for God knows how much money. I didn't even look. I just Googled the words in AliExpress and get the El Cheapo version. And yeah, it might not work. It might take 7 weeks to come. But, it's a little bit of, random shopping. So I'm going to go to Marcus first because I interrupted his hand in the
I
air.
was just saying, if you're paying with a credit card or PayPal, you're pretty much safe with any transaction, doesn't matter how the world is from these days. And when consent first started, I think people were concerned, but now it's a lot safer to pay with a credit card.
Like, pretty much all cards come with some consumer insurance, don't they?
Yeah.
From that person.
So it feels victimless. But I think that's right, that what we're doing is we're pushing our risk off. So we are recognising risk, but we're saying, okay, actually, somebody with deeper pockets than me can deal with that risk. You pay, most of us understand that we're paying for that in some way, that there is a cost involved with using a credit card or PayPal or whatever that thing is, but we're pushing off our risk in that way. So we are dealing with it in a quasi-contractual sense. We'll come to Harry and then over to you.
A couple of our clients are big on buying fixtures and fittings for building works from overseas. And we've found that close to 50% of the products really break down in the first couple of months of use. Whereas comparatively speaking, Australian supplied or internationally supplied products from the US, although there might be a less faulty element to them, the resolution and the remedy of replacing those goods is expedited far quicker.
So again, but that's a risk question, isn't it, for your clients or somebody who's making that buying decision?
But it tends to be a false sense of economy at the end of the day in this particular application.
Not if you liquidate the building company and move on.
Nobody's
You're
ever
far
done
more
that
ethical.
before.
Never. Never happened before.
Jamal.
I think one thing where we're talking about credit card use, I've moved away from, it's not actually about the use of the credit card because there's insurance, etc. that's now built in. It's actually more about privacy and use of personal information and fraudulent use of your identity as well. So what I look at the website is, are they going to steal my identity? And look for more information about me, because that's probably the biggest risk at the moment around websites that are just phishing your information as well.
Yeah. And there's a lot of personal information attached with a credit card. So again, one of the reasons why some people choose to use the, what do you call them, supermarket debit cards for online transactions.
What's not sort of transparent to me in all this, because we've got a lot of clear ideas around personal information and rights and responsibilities, or this is a conversation around that, but what I'm not clear on and haven't read anything about is how we handle consumer behaviour on websites and how that leads to, sorry for anyone that's read my question on the thing, but it's still something that's in that space. We don't know what the ownership of that is, and then collecting all
And I
the
think that's a
data
big
about
issue that's really only just starting to come into sort of the legal frameworks now. Because contract in particular, and a lot of this stuff has fallen into, as I think Gordon really beautifully pointed out, that we're dealing with this 200-300-year-old framework that might have made sense when you were doing things in writing and you were moving a horse from one farm to another farm, or everything's happening by the most modern equivalent is a telegraph, to what we're actually moving now with both tangible and real property, and the way that people behave and the amounts of money that are moved, and the kinds of risks that we look at. All of that stuff is changing. So there's a lot of work that's been done over the last 15 years or so in what's considered a relatively new field of economics called behavioural economics. So the pop star in that area is a guy called Dan Ariely. Any of you who are fans of TED Talks, if you want to amuse yourself, you know, if your Saturday nights are as fun as mine, you can watch some Dan Ariely tonight. He talks about, he does experiments about the way that humans behave in predictably irrational ways. So in fact, one of his main books is called Predictably Irrational. So he does experiments around how for example, when choices are hard, humans elect not to make a choice at all. So he compares, for example, organ donation rates across a whole range of companies and countries, I should say. And organ donation, it's a very binary thing, as it turns out. It's in most countries, either lots of people agree to donate their organs or hardly any do. And so this is quite interesting. So you think initially, oh, there must be a cultural thing. You know, sort of certain religions won't want to donate their organs, and so if, you know, countries are predominantly of those kind of religions, maybe that's it. Then you look at the data and you think, actually, I can't remember exactly. If you see the TED Talk, you'll see. But so two of the, I think, you know, maybe it was Denmark and Norway. You would expect the outcomes in those countries to be pretty similar. Two Scandinavian countries, similar cultures, diametrically opposed results. France and Italy, I think, were another two, again, where you would think fairly similar religious, fairly similar kind of culture in many ways, you'd expect similar results, very, very different. So this becomes this question about why people make these choices. And so actually it came down to looking at how the question was asked. So if the default position was, unless you tick this box, you've agreed to donate your organs, sort of option one. Option two is, if you want to donate your organs, tick this box. It's a hard question, so people don't answer it. So the default position becomes the end result. So that's just one example of how behavioural economics works. So people and it's often also referred to as nudge economics more recently. So there's actually a nudge department of all things in the UK. They obviously should have done a little bit more work with the Brexit vote, but they literally look at ways that they can word or structure experiences for consumers of government services to nudge them into making wise choices, or the choices that the government of the day wants them to make. So defaulting circumstances to avoid the hard decision to get the result that they want. So a lot of work's been happening into behavioural economics, and it's only more recently that people have started to think about nudge law. Like, to what extent actually is nudge exercises or experiments, to what extent is there a legal responsibility associated with that? And when you think about the kinds of contracts that Gordon was just talking about earlier, where we've got pages and pages of, I think the language was turgid and impenetrable terms, when it's hard to read the terms and you just want to go and play online Scrabble. Any fans of Natalie Tran here? No, you know. Right, there's a very old Natalie Tran YouTube video about playing online Scrabble and inadvertently selling your soul to the devil. It takes 2.5 minutes. I'll play it at the end. So when it's hard to do that, and the experience that you want, the piece of software, the ability to play Candy Crush, online Scrabble, whatever the thing is that you want, or the ability to, when you're standing in the rain, to get that Uber to come to you right now, means that the convenience, it's hard to go through that stuff. It's hard to think about it, hard to know what it means or to think about how it might apply in the future, so we just move forward. So that does raise the question, do you have a duty of care to end users of your terms and conditions to have them work in a particular way in this environment. Now, there's nothing in the law that would suggest that you do. And there's nothing in the common law at the moment that would lead us to that end result, although perhaps that Uber case is the beginning in America of that way of thinking. The only way that end result is going to happen here is if it is pushed by legislation. And I do wonder what kind of response you would get to a claim of that sort. But I do challenge you as we're thinking about these things, because, like I keep saying, the law of internet is like the law of puppies or the law of shoes or something. It's quite a meaningless term. It does challenge you to stand back and think, well, how might our legal system be different if we had the internet and the kind of technologies that we have today when we were setting it up? Would it be set up the same way? I'm hoping, actually, Ben sent me a photo of the booth for the democracy people at the Emerging Tech Festival yesterday, My Vote. And I think I might be able to get him to come in and have a chat with us in 2 weekends' time. We had a very robust conversation about how democracy might work, and I think if we can make the time work, I think it'll be really interesting and a robust conversation. We'll see what we can do.
Yeah, for context, the question that was posed on their booth was, how can blockchain improve democracy? And I thought it's very clear.
Yeah, it was very clear. As it turns out, blockchain is a very minor part of what they do.
Oh, really?
Yeah, they do actually use it. He said he was just embarrassed by the whole thing.
I thought it was a really sexy statement.
Yeah, I think that's what it made me go over and talk to him.
Yeah.
But yeah, but I will at least explain what they're doing and challenge you to think about it. So I guess that's, as usual, wandering off on a bit of a tangent, but I want you to think about why we're going to talk about these international frameworks, and really just challenge you to think about, well, how relevant really are they? Is this just a set of governments trying to play catch up? And at the end of the day, we're not even getting these things ratified at the international level anyway. Or does it actually really matter? A contract is a contract, the principles are there, and people are taking risks, because that's what contracts are about, really, the allocation of risk. And the market ultimately looks after itself. And will it be that as we know and understand more about markets and how they work on an international scale with the internet, that the law will continue to play catch up? Or is this, or are we exploring a whole range of areas where lawmakers need to stand up and be preemptive about what the law should be? And it's nice to have the luxury of being able to think about it. So, as I mentioned before, we've got the UNCITRAL model law, and its purpose is to offer national legislators a set of international solutions to legal problems associated with the use of electronic commerce. A worthy promise, no doubt. So what does it address? The formation of contracts by electronic means, governance of electronic contract performance, characteristics of valid electronic documents, recognition of electronic signatures for legal and commercial purposes, and this idea of computer-generated evidence. So, broad brush, broad sweeping set of requirements. We spoke a little bit when the other Julian was with us last week about computer-generated evidence. So we started to talk about the idea of the extent to which there are native documents, so documents that are not necessarily ever on paper format, and the extent to which computer analysis can be used to create evidential outcomes. What I really want to talk about very briefly today is electronic signatures. And about the validity of electronic transactions. So, Section 8. For the purposes of... we're in the Electronic Transactions Act. I haven't put a heading on that slide. So, this is the Commonwealth Act too. For the purpose of the law of the Commonwealth, a transaction is not invalid because it took place wholly or partly by means of one or more electronic communications. So again, as Gordon pointed out today, there is no controversy about whether a contract can be made online. Electronic communication itself satisfies the requirement for writing, as that previous document said. Interestingly enough, in relation to statute of frauds matters, particularly in the property space, it has been practice, and government departments have been very slow to meet this standard. So there has been an ongoing requirement for physical documents. And some legislation still requires physical documents, particularly at the state level. A legislative requirement for a signature is satisfied if it involves a method which is as reliable as was appropriate for the purposes for which the information was communicated. And a requirement to produce a document can be satisfied electronically. So in theory at least, the days of the paper document and the requirement for a paper contract are done. Document retention can be satisfied electronically. So a requirement under a statute or otherwise to hold a document for a period of time can be met by simply keeping that document on a computer server. There is nothing to suggest that keeping it on the cloud wouldn't meet that requirement as well. Other things there, anything of particular interest? No. In 2011, there were a range of recommendations, most of which were picked up for the for amendment to the Commonwealth Electronic Transactions Act. Ultimately, the Commonwealth Act forms the basis for a code, so there are matching state-based pieces of legislation. I think those of you who spent some time with me in contract would have looked at the Victorian Act at some point, or at least fooled me into thinking that you did. So, again, nothing particularly exciting there, but there is a process for dealing at a legislative level with electronic material. So, let's talk just briefly, I know it's just because of timing, but about what an electronic signature is. So we talked about the browse wrap, click wrap, sign-in wrap. It sounds like some sort of poetry. Those kind of contracts. Other contexts where you might see an electronic signature. So the clicking OK or I accept is a signature for the purposes of those contracts. There's no controversy there. What other spaces might you see an electronic signature? James?
If you write your name at the end of the document.
Writing your name at the end of the document. So an exchange of emails or something like that, do you mean? Absolutely.
In post, when you receive parcels and you have signed for them.
So with their on the digital thing when they come to the door.
Yeah.
So you can tell I do a lot of AliExpress. They're always at the door.
Or when you go to the Apple store and they get you to sign your credit card on their little sign pad thing. But I was going to say things like encrypted PDFs and stuff where it's been digitally signed by somebody.
So where there's a digital signature as opposed to an electronic signature. So, and I think this is really important. At least there are different ways that we can sign. So we think about sign in the layperson sense of signing a document. So originally a signature was really, and it's just a mark. It's something that says this human has at least acknowledged the existence of some serious undertaking. So initially a signature might have just been an X or a fingerprint. Just some sort of mark. It can be the flourish, the signed, sealed and delivered that we talk about with deeds, bringing up that level of seriousness to the next step. So it's not just the signature, but it is physically sealing the document, the wax seal or the imprint. and an act of delivery, some sort of action or statement that demonstrates to the world acceptance of the terms. Online or in an electronic sense, yes, it could just be as simple as an exchange of emails, perhaps with some sort of image of somebody's signature, perhaps not, just with a sign-off with their name and their phone number and an email address that is known to be, or at least appears to be, unique to that individual. It could be a physical signature using some sort of electronic device for recording existence. You trying to say something, Jamal?
Something blockchain, like a unique key.
And that's exactly where we're getting to with Elise's point, some sort of private key or encryption key, some unique identifier that is attached to an individual, or at least. So, and this is one of the biggest issues that people are having with blockchain, one of the biggest problems, because I guess blockchain ultimately is just a technology. You know, so it's kind of, in one way, we're talking about blockchain in the way that maybe 10 years ago when this course was written, we spoke about the internet. It's like, at the end of the day, I think we have to stand back and remember it's a technology that helps people do things. And it's a technology that has some incredible strengths with a distributed ledger and a range of different opportunities when you don't have a single owner or a single central authority. But it also works on the basis that if you've got a key, if you've got a personal key, then you are that person. So actually, how do you keep the key safe? So unless you can actually, the person who has the key, is there any way of actually identifying whether that key is owned by the right or kept by the right person or not? And is that the new kind of, or a new kind of computer crime, the theft of keys? So, with every great opportunity comes a new threat, I guess. So we have this idea of both an electronic signature that could be a scanned copy of somebody's handwritten signature, or it could actually be some sort of complex encrypted private key. So, what are we saying here? What does the Act say? Oh, I'm printing out Gordon's slides, which are very easy to read, and mine are tiny. This is just coming straight. So Section 9 from the Victorian Act basically just says pretty much any of those things can be an electronic signature. So it then goes back to the parties as to what kind of signature they may or they may not want. Okay? Because the kind or the level of signature that you need itself might be a term of the Victorian Act. So, what have the court said about the reliability of electronic signatures? A couple of cases here, still relatively recent. So in Alonso, which I'm going to look here because I can read it better, when determining whether or not a signature will be considered reliable and appropriate for the purposes, the court in Alonso looked at whether the party's conduct, viewed objectively, reveals tacit understanding or agreement or a manifestation of mutual assent, which evidences an intention to create legal relations. Nothing exciting, nothing new, nothing really very different at all from how we understand assent or agreement in contract law generally. This position is followed in Australasia Freight and Turner. In that case, the court held that the absence of any formal written contractual documents, correspondence between the parties that included oral agreements and emails was sufficient both in writing and signature to create a binding agreement. The court noted, although, that the Instruments Act applied to that agreement and the conditions set out in 126 can be met in accordance with the Electronic Transactions Act for Victoria. So Section 126, as you will remember no doubt, is the statute of frauds equivalent in modern Victorian legislation. Is that a meaningful statement, Jen? Is that some of you who did contract a long time ago? So statute of fraud requirement for writing. A couple of other cases here that might be of interest. Brown Brothers. VCAT, so not particularly persuasive anywhere really, But still, there aren't that many cases around, as Gordon pointed out. Persuasive, I would say it's useful, fantastic tribunal.
I was once doing a moot and I found a really awesome, that was totally on point, exactly the same facts, fitted my scenario entirely, and it was from the Federal Magistrates Court, and I'm like,
Yeah, well, that beats VCAT, Federal Magistrates Court.
probably can't use that.
Yeah, go with the
Well,
Go with the wins.
but the thing is, it's kind of interesting when the points aren't controversial. You know, we need to have a controversy in order for there to be an appeal. Okay, so it's actually only the controversial points that we get detailed law on. So to have authority for something like this, I mean, VCAT's the best I can do. If you can come up with something better, your participation might will skyrocket. So VCAT found in that case an email satisfied written notice requirements under the Domestic Building Contracts Act. And further stated, under this case, Legal Services Board and Forster and Forbes and Cameron, that a typed-in signature is enough. GetUp and the Electoral Commissioner. Court found that an electoral enrolment application in which the applicant had signed using a digital pen met the criteria under the Electronic Transactions Act, noting that the method both identified the signatory and their intentions and should therefore be considered reliable. It's increasingly difficult to argue that electronic transactions and signatures don't constitute binding agreements or meet signatures requirement.
Wasn't that decision responsible for another 70,000 people's votes to be
Yeah,
able to be cast? Like, pretty major what they achieved with that.
exactly. So it's pretty interesting. Okay, so the existing contract principles apply. Just thought I'd make sure that we're all on the same page. What are they? What are the broad principles? What do we need to make a contract?
Agreements.
Murders of all the right sort. Absolutely. So we just need to look for those same things. This is really only relevant these days from the point of view of writing these contracts. Now, we don't have this meeting of the minds in the same way with electronic contracts and the kinds that Gordon was talking about earlier. We're not going to be able to point to negotiations and deep thought, possibly any thought at all. And I think it does. I think he raises some really valid points about whether or not we should be thinking about this differently. But these are the principles we're dealing with, and that's what we have in front of us. So, yes, contract is an agreement made between two or more parties. It's legally enforceable. It can be verbal. It can be oral. A contract arises when one party makes an offer and the other party who has capacity communicates an intention to accept it for consideration. Too easy. And we can create a contract by signing it, selecting a product in a shop and paying for it at the checkout counter. That's the offer. The acceptance is the cashier, or clicking on an I agree button. All right. I'm going to whiz through these because we did talk about them. And he's also spoken quite a bit about the unfair contract term regime. My slides have a little bit more information, but I'm just trying to work out what we need to talk about there. Are there any particular issues in relation to unfair contracts that, again, I'm kind of with Gordon here, it's actually a bit dull. We just do need to think about it from the point of view of making contracts. Well, firstly, from our consumer rights point of view, because that's naturally where we go to, but I want you to also think about it from the point of view of advising people who are seeking to contract online. Because in almost every case, a straight click wrap or click through arrangement will be a standard form contract. There's a disparity in bargaining power, there's no capacity for negotiation, they're almost always consumer contracts, and if they're not consumer contracts, they're likely to be small business contracts, because when they're not, there's an element of negotiation almost always. Although, as Jenny Patterson always likes to point out, in the entire time that she worked for Mallisons and was negotiating contracts for the National Australia Bank, the only party who ever came to the table with their own first draft of a loan agreement was BHP. Like, you do need to have a certain amount of, they who draft have bargaining power. And yes, in large transactions, sometimes there'll be some argy-bargy about it, but you pretty much know when you start with a standard form contract, the more power you have, the less likely that is to move, or bargaining power you have, the more less likely it is to move.
Just wondering though, what's the considerations? So with eBay, I'll click on to their contract if you like to use eBay, but where's my consideration?
So
I'm making a contract with you who's selling a good, not so much my considerations with you.
But,
with eBay.
but both you and I have agreed to use the eBay platform.
So they pay.
So say I'm selling you something, I've signed up to some terms and conditions that allow me to advertise my BMX bike, fully sick, only ever done awesome tricks, picked up 3 11-year-old girls when he was only 12 on that BMX. It was like, it's a surefire winner BMX bike. Absolutely, I describe it, all the rest of it, and I agree as part of those terms and conditions that I'm going to pay a percentage or a fixed amount, whatever it is. I can't remember, it's a while since Gumtree is our latest second-hand goods selling place of choice. So that's fine. Then I've agreed to pay a commission. I may have also agreed to pay a commission to PayPal, which until relatively recently was still part of the same organisation. So they had to separate the terms. So that's my side. And I've also agreed that I'll comply with certain rules, so that I will only sell to the highest bidder, or I'll sell in accordance with a set of rules. Then you've come onto the platform as well, and you've agreed with them as a purchaser. Well, what kind of things are you agreeing as a purchaser? You're agreeing that they've got your information, so there's consideration, you're giving them something that belongs to you, that you'll use the platform in accordance with the rules, that you are who you say you are, and that you'll pay in accordance with those terms and conditions. So essentially you're agreeing to get the benefits of using the platform, the ability to search and find that 46 BMX bike that I just know you want to buy. You've got your access to that information, so to that service, in exchange for promises that you'll comply with their rules. So remember, there doesn't have to be value. This is a two-sided platform. eBay's a two-sided platform, but only one side actually pays cash consideration.
What happens though, because eBay often offer free transactions for sellers and their purchasers. Does that mean that my contract's, I haven't got a contract if I'm...
Well, what do we remember about consideration? Consideration needs to be sufficient. Well, it needs to be adequate, but it doesn't need to be sufficient. I always get those words back to front. It doesn't need to be valuable. Pardon?
The benefit detriment requirement.
Exactly. For extra points, go with the case.
So the free,
Go on.
the free is the benefit.
You just finished.
So, no, the free's not necessarily the benefit. There's a range of things that you're getting a benefit for. You're exchanging promises. So promises don't need to be cash. Remember, consideration moves from the promisor, which really means both sides need to make a promise, unless you're in a unilateral contract where somebody's already done something and then the promise kicks in. But both sides need to make and keep a promise. So a promise in exchange for a promise. Now, usually in a straightforward bilateral commercial transaction, that is, you promise that I can own something if you give me cash. But actually, it could be, I'll promise to do things in accordance with that set of rules if you give me access to that information. So, but you're on the right track to think about, well, where is the consideration? And sometimes you need to think, even if it's peppercorn consideration, you need something. And so sometimes that is actually the rationale for the sign-through arrangements. So one of the things, those of you who don't, like me, don't care about privacy, will possibly click through and have the opportunity to sign in with Google, sign in with Facebook, sign in with Twitter, whatever it is. But then usually you'll get to another screen which will say, this is what you're doing. By agreeing to access this way, you're going to share information about who your friends are or whatever that happens to be. Sorry, Martha.
I was just going to say, in terms of consideration, when you just press I agree, is that like with the Uber example, it's raining, I really want my Uber, sign in, yes. Is that sufficient consideration?
Well, what you're doing is, so you're describing a case where you've already subscribed, you're already on the Uber platform. So at that point, you're hitting your button to say, send the Uber to me now, which is essentially you're promising, I will pay for that service if you send me a cab now, send me an Uber now. When you're signing into the service, you're already giving them your credit card information or something like similar up front, and information about who you are. And you're essentially saying, my initial part is I accept the terms and conditions, and I agree that in the future, when I hit that send me a cab now, I'll do it on your terms and conditions. And it might be, I haven't particularly looked at Uber, but it might be that those terms and conditions might change quite regularly.
It's like the surge.
Yeah, well, for example, you agreeing that they might be a surge charge, for example, then when you hit the button on the particular night, it'll come up and say, actually, we're going to charge you 1.3 times or 2.6 times or whatever it happens to be. So you're hitting that accept at that point. Yes, and I'm very lazy. I have done that more than once. I'm not proud. So, okay, I think just want to point out this effect of unfairness in consumer contracts, because I don't think that there's any real potential for an argument that most web contracts are consumer contracts. It's always worth having a look if you're trying to get out of one, but most of the time. So we need this sort of combination of events though, as Gordon was pointing out earlier, in order to ensure that you have a claim of an unfair term. So first we need to have a contract that is a standard form contract. We've actually spoken about it already, but in the past I was planning to talk about it in the future. We need it to be a consumer contract. Again, pretty easy to meet. The term itself has to be unfair. This is where it gets a little bit difficult because there is no standard definition of what's unfair. Again, I think this is actually being quite cleverly drafted in a sense that unfair will depend on a range of factors, including the circumstances, and including a common perception of what unfairness means. And it's only when we have all three of those things that the term will be void. Now, what makes this a little bit more complex here is on the first time one of these terms is identified, the outcome is void. So it requires somebody to actually make a claim and have a declaration that the term is void. It's only after that's been undertaken that the circumstance can arise that if that term remains in the contract, that subsequent users of that contract can actually claim damages as well. So 3 tests: significant imbalance, and it needs to be not reasonably necessary to protect the legitimate interests of the advantage party, and would cause detriment if relied on. Those I'm guessing are impossible to read from there. They're summarised. I'll make sure you've got a copy of them. They're summarised straight from the legislation, and I'm not saying anything that Gordon didn't say before. In fact, as I look at them, I just want to move forward rather than skip through because we're just going to double up. What I thought was interesting is in working out whether a term is unfair or not, there has been some guidance in the legislation as to what the courts will consider. So specifically, they look at bargaining power, which in a website situation is almost always very heavily weighted to the provider. Whether the contract was prepared by one party or another, again, always one-sided in a web contract. Whether a party was given an effective opportunity to negotiate, it's usually a binary choice. Click here, accept, and you can move on, or we're not going to contract with you. Whether the terms of the contract, other than the terms that are specifically referred to in section 26(1), which are things like the amount, example. So it's not, or the methodology for disputes in many cases. Whether they take into account the specific characteristics of another party or a particular transaction, and whether another party was in effect required either to accept or reject the terms. So, the other thing is here, I just started talking about this before, often with consumer contracts in particular, the amounts are quite small, and so it's not really worth a consumer's while doing a Balmain ferry and taking something to the High Court over, what was it, 2p or something? No, it was 1 penny, wasn't it? Yeah. So essentially the ACCC can bring an action in relation to it. May not necessarily do so, but it can bring an action to have a term declared unfair. So while a private consumer can do that if they wish, usually the first port of call would be to make a complaint to the ACCC. ACCC can also seek an injunction. On first instance, neither the ACCC nor a consumer can get damages. All they can do is get a statement that the term is void, and then the flow-through consequence of that. So if the contract actually makes no sense without that term, then the contract itself is entirely void. But a contract may in fact be able to exist without that term being unfair. So early use of these provisions related to the fair use provisions in mobile phone contracts. So unlimited data, unless you actually download anything. No damage. Okay, only just got that little bit, the unless you download anything bit taken away. Compensation claims. So when the reliance on a term after the declaration of unfairness is made, compensation can be made by a person suffering loss, but somebody else has to go first. And that includes the ACCC taking a damages amount, including costs, or an order of redress, loss or damage to a non-party consumer. Now obviously a person who is the consumer can't be a non-party consumer, so they can't actually claim that. Okay? In addition to unfair contracts, we also have this idea of, under the consumer law, of an unconscionable contract. So a person must not engage in unconscionable conduct, taking into account the parties' respective bargaining positions, where the consumer is able to understand any documents and the extent to which the supplier was willing to negotiate terms and conditions. So, biggest case in this area in recent times is the Lux case. Has anybody heard about Lux? So, sorry?
So what was the name of the case?
Lux and the ACCC. So it basically involved vacuum cleaner sales. There's no need to read it here in particular, so I haven't put it up as any of the reading. So basically, Lux sold high-end vacuum cleaners, like really high-end, like I think they were like $1,500 a pop for a vacuum cleaner. And what they did is they sent their sales teams out into the leafy suburbs of Sydney and Melbourne, and they essentially went to the homes of, well, during the day, tended to offer lonely middle-aged or elderly people who are at home during the day the opportunity to have their vacuum cleaners checked and serviced for free. So they went in and they basically had a whole business methodology. There was evidence that showed that they targeted particular households. They had scripts essentially for people who appeared lonely. Part of the whole aim of this was to get a cup of tea very early on in the piece. They would check out somebody's vacuum cleaner. They would say that it was just terrible and that they were probably going to get asthma and that their grandchildren were going to suffer, and ultimately sell these high-end vacuum cleaners to them. These were not people who would typically be considered disadvantaged in a normal sense. They were white, Anglo-Saxon, generally quite well educated, English as a first language, but they were a particular, again, behavioural economics, they were a particular demographic who were quite happy to have people come into their home and give them a cup of tea. This all happened before the door-to-door sales cooling off legislation had come in. And so the question was whether or not that conduct was unconscionable conduct. So taking advantage of somebody's disability or weakness in order to sell them something that they didn't need. So what do you think happened?
Well, you described it, I hope that the ACCC won.
The ACCC did win, but not without some controversy though. And there's this kind of line of cases that to well, what is the responsibility? And in that case, they found that there was a marketing campaign, essentially an approach to marketing that had identified a particular way of selling to a consumer who probably didn't need the product. They were taking advantage of a particular set of circumstances. They knew that these people could afford it, or they probably didn't know, but they could guess that they could afford it. They thought that they were all right because they weren't, part of their sales rules actually said, be careful if they don't speak English as a first language, you want to get out of there quickly because we might have problems selling to them, etc. So they were taking advantage of a particular situation. So, the question, I guess, and I leave it as a question, what are we doing for time? Because we'll finish up here. I want you to think about is the extent to which this legislation might actually be relevant in the kind of cases that Gordon was just talking about. To what extent is it that standing in the rain, waiting for the Uber, trying to get away from that just one more drink call that somebody else is calling out, you just want to get home, to what extent is taking advantage of that situation, if it's known or likely to be known by some sort of data analysis that puts surge pricing on, how would that work?
2.3, and you're just like, I've just paid $50 to get home. I could have bought a taxi for less.
So, but you didn't take a taxi for less.
No, I caught an Uber.
So, question. And I don't know the answer to this, but I do wonder if there are different ways than just traditional contract law for approaching these kinds of questions. And whether, in a particularly Australian context, where we have consumer laws like this, if there aren't different approaches that might be relevant. I don't know. So I want to leave, that's all I really have to say about contract. I think between Gordon and I, we've spent enough time on it already. Other than to the extent that you have questions or comments now. Nothing like saying lunchtime to make people quiet. You guys are quieter this weekend. Julian's going to be here at 2 o'clock to start talking about artificial intelligence, and so we'll kick off from then, and then I'll go on to jurisdiction, I think. And then tomorrow will all be about data protection. A lot more fun. Cool.
Well, we definitely don't.